Mr. Burgess.
Mr. Chairman, good afternoon. I'm going to turn the witnesses over here to Mr. Ziegler in 1 second, but we do have a administrative matter that we need to tend to, so we keep the record straight in this proceeding. Yesterday, ORS moved into the record the testimony of Iris Griffin, which occurred at the federal preliminary injunction hearing, and this commission allowed us to insert the entire transcript of Ms. Griffin's direct, cross, redirect. So we're going to put that into the record with Ms. Wheat. I'll get straight with her on that. In speaking with Ms. Edwards of ORS, she also requested that we include the exhibits which were used at the preliminary injunction hearing with Ms. Griffin. We have no objection to that. So we have those exhibits here with us. So at this time, we would move into the record the exhibits that ride with Ms. Griffin's preliminary injunction testimony from the federal court proceeding, and ask that those be marked as the next hearing composite exhibit.
I'm going to get Mr. Butler to talk with you about it and make sure we get everything right.
All right.
Hey, Mr. Burgess, excuse me, do you want that as part of the other exhibit so it'll all be together, or do you want this as a separate exhibit?
Mr. Butler, my understanding was that it would be, it would be a separate exhibit because Ms. Griffin's testimony was moved into the record as if given orally from the stand.
Okay, I understand, and that's fine.
Thank you, Mr.
Okay, Mr. Chairman, yes, that would be number 100.
Okay, we will enter the exhibits as exhibit number 100. Okay, Mr. Ziegler.
Chairman Belton Ziegler with the law firm of Womble Bond Dickinson, appearing for SC and G. I'll begin with Dr. Lynch. Dr. Lynch, could you state your name for the record, please?
Joseph Lynch.
By whom are you employed and in what capacity?
I'm employed by Scanner Services Company as the manager of resource planning.
Dr. Lynch, I'd like to turn your attention to the pre-filed testimony in Docket 2017-370E. Did you prepare or cause to be prepared under your direction certain testimony pre-filed in that docket, which includes 2 sets of testimony, that is 33 pages of direct testimony and 14 pages of rebuttal testimony?
I did.
Are there any additions or corrections to either set of testimony?
No.
If I were to ask you the same questions that are contained in that pre-filed testimony today, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time I would move Dr. Lynch's pre-filed testimony into the record as if given orally from the stand.
Dr. Lynch's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Now, Dr. Lynch, attached to your pre-filed testimony in your pre-filed direct testimony in Docket 2017-370E, there were 10 exhibits, were there not?
Yes, they were.
Are there any changes or corrections to those exhibits?
No, they're not.
Mr. Chairman, I would move that those exhibits be moved into the record here as the next hearing exhibit.
Dr. Lynch's exhibits will be entered as exhibit number 101.
Thank you, Mr. Chairman. And Dr. Lynch, as to your rebuttal testimony in that docket, there were 2 exhibits attached to it, were there not?
Yes, sir.
There were JML1 and JML2, correct?
That's correct.
And you filed an amended version of JML2, which was simply a color version of the chart that was contained in that exhibit, whereas a black and white version had been originally filed. Is that correct?
That's correct.
Mr. Chairman, I would move that Dr. Lynch's exhibits in the rebuttal testimony be admitted into evidence using the amended version of JML2.
They will enter Dr. Lynch's exhibits, including the amended color version, as hearing exhibit 102.
Dr. Lynch, I turn your attention to your filings in dockets number 2017-305E and docket 2017-270E. Did you prepare or cause to be prepared under your direction certain direct testimony of 13 pages and certain rebuttal testimony of 10 pages that was pre-filed in those dockets?
Yes, I did.
Are there any changes or additions to this pre-filed testimony?
No, they're not.
If I were to ask you the same questions today as are contained there, would your answers be the same?
They would.
Chairman, I would move that pre-filed testimony to be admitted into the record as if given orally from the stand.
Okay, Dr. Lynch's pre-filed surrebuttal testimony will be entered into the record as if given orally from the stand. And I don't think we did his rebuttal. I don't think we've entered that.
Did we miss his rebuttal?
We missed that part. We got his exhibits, but
Let me go back then to,
you may have asked. I may just not have said it.
it's very possible I did. Let's say that there are 14 pages referring to Docket 2017-370. There are 14 pages of rebuttal testimony that you've pre-filed in that docket, are there not?
Yes, sir.
And if I were to ask you the questions contained in that rebuttal testimony, would your answers today be the same?
They would.
Are there any changes or corrections to that rebuttal testimony?
No, sir.
Chairman, we'd move that testimony into the record as if given from the stand.
Okay, Dr. Lynch's rebuttal testimony will be entered into the record as though given orally from the stand.
If I've got my place marked correctly, we're now to the second set of exhibits in the other two dockets. So I'm referring now to Docket 2017-305 and Docket 2017-207, both of them dockets with the ending E. Attached to your surrebuttal testimony, I believe there was one exhibit. Is that correct?
That's correct.
Are there any changes or amendments to that exhibit?
No, they're not.
Chairman, I would move that exhibit to be entered into the record of this proceeding.
Okay, Dr. Lynch's surrebuttal exhibit will be exhibit number 103.
Thank you. Have you prepared a summary of your testimony in these proceedings, Dr.?
I have.
Would you please provide that to the commissioners and those who are present here?
Good afternoon, Chairman Randall and members of the commission. In this proceeding, I have filed 4 sets of testimony. The first set was direct testimony under Docket 217-370E. The purpose of this testimony was to review the economic analyses that SC&G's Resource Planning Group prepared at various times over the past decade to assess the comparative economic costs and benefits to customers from completing the project to construct 2 Westinghouse AP1000 nuclear units at the VC Summer site. That's the NND project, compared to other alternatives for meeting customers' requirements for baseload generating resources. In the original 2008 docket, SC&G showed that constructing units 2 and 3 provided the best combination of system economy of any alternative under reasonable assumptions about the future fossil fuel prices, environmental regulations, and load growth. Renewable power and energy efficiency were considered, but found to be incapable of replacing the baseload energy provided by a nuclear plant. In dockets 2012-203E, 2015-103E, and 2016-223E, my testimony presented economic studies comparing the alternatives of continuing construction of the nuclear units to that of stopping construction and building combined cycle units instead. These studies were pre-filed with my testimony in these dockets and were subject to discovery and responsive testimony. I modeled 27 individual scenarios in each study to provide sensitivities related to factors like carbon costs, gas prices, and future demand levels. Both my 2015 and 2016 studies included a sensitivity analysis that showed that the cost of units could increase by $3.1 billion in 2015 and $3.8 billion in 2016 before the break-even point was reached. In all 3 dockets, SC&G studies showed that continuing construction of the nuclear units was in the best interest of our customers. The 2016 testimony included an analysis of the recently negotiated fixed-price option, demonstrating that signing the option was reasonable considering the cost risks to the project. Additionally, in 2016, the ORS asked the company to model the cost of delaying the units for 18 months and 24 months, including the loss of federal production tax credits. The company did so and provided the results in response to AIR 138. The result was an increase in the cost of $84 million per year in both cases, which compared to net savings to customers in the underlying studies of $374 million per year. Delay and loss of PTC would not have changed the conclusion to continue the project in 2016. My testimony also contains an analysis of the economics of continuing construction of the nuclear units after the Westinghouse bankruptcy. 4 options were considered. Complete both units with Santee Cooper as partner. 2, complete Unit 2 and abandon Unit 3 with Santee Cooper as partner. 3, compare Unit 2 and abandon Unit 3 without Santee Cooper as partner. And 4, abandon both units. This analysis showed that option 1 with Santee Cooper as partner could be justified based on the economics, even with the later completion dates and higher construction costs identified at that time. But without Santee Cooper as partner, this justification would be difficult. SCG's economic studies use standard industry techniques. The ProSim model is widely accepted in the industry as a tool to simulate the dispatch of a utility system and estimate production costs. SCG combines ProSim results with an Excel capital cost model to derive incremental revenue requirements. In the original docket in 2008, ORS retained several consultants to review aspects of SCG's planning methods, and our methods were found to be sound and well accepted in the industry. In this proceeding, I have also filed direct testimony in dockets 2017 207E and 2017 305E, and surrebuttal testimony in docket 217 370E. These sets of testimony address certain claims of Dr. Cooper, witness for the Sierra Club and the Friends of the Earth. While I address many of his criticisms in my testimony, in the interest of time, I only address a few in my summary. Dr. Cooper claims that my economic studies are all fatally flawed and represent tooth fairy economics. My response is that SCG's planning methodology is reasonable and standard in the industry, and that the detailed review performed by ORS's consultants in 2008 verify that this is so. Dr. Cooper also claims that SCG is too pessimistic about future natural gas prices. I respond that SCG did not make a forecast of natural gas prices, but conducted a sensitivity analysis using a range of future prices because of the belief that future gas prices cannot be projected with confidence. I included the baseline price forecasts made by the U.S. Energy Information Administration, the EIA, which projects prices each year. The EIA baseline forecast always lined up with our middle price scenario, suggesting our sensitivity range was reasonable. Dr. Cooper also claimed that SCG's expectation for CO2 emission cost was too high. I responded that SCG did not make a forecast of CO2 emission costs, but conducted a sensitivity analysis using a range of possible future CO2 emission costs, namely $0, $15, and $30 per ton. I also point out that just because CO2 emission costs are zero today in South Carolina, that doesn't mean they will be zero over the next 60 to 80 years, which is expected life for these nuclear units. In fact, the last estimate of the social cost of carbon made under the Obama administration was a price of $54 per ton in 2020, well above the upper value in our sensitivity range. Other estimates are even higher. Dr. Cooper points out that SCG's initial demand forecast was high. While this turned out to be true, I would point out that the Great Recession of 2008 has changed the course of the economy in unexpected ways. I also say that a forecast showing little or no growth following 30 to 40 years of almost continual historical growth in demand would be difficult to accept, especially when SCG is responsible for having the capacity to serve that load. With regard to forecasting, I can attest that SCG puts in a significant effort to produce a good forecast, and our methods are as good or better than most utilities. And that is what the ORS's consultant, Dr. Zhu, found in 2008 when he scrutinized our methods. Lastly, in this proceeding, I submitted rebuttal testimony in docket 2017-370E to address some of the comments of Mr. Richardson, witness of the ORS. Mr. Richardson discussed the 2015 economic study in some detail. He correctly pointed out 2 mistakes that were made. I respond that the correction of these mistakes would not come close to changing the conclusion to continue with the nuclear construction. One mistake was positive for the decision to continue nuclear construction, and the other negative, but neither came close to changing the conclusion to continue the nuclear construction, either separately or taken together. On other criticisms made, Mr. Richardson is just wrong. For example, he claims that transmission investment was not considered abandoned in the 2016 study, which is not true. Prior to the Westinghouse bankruptcy, the transmission investment was not considered separately from the total NND project. He claims that a tax abandonment benefit was available and should have been included in the 2015 and 2016 economic studies. The abandonment tax deduction had not been identified in 2015 or 16, and a salvage approach was modeled instead. Mr. Richardson claims that we overestimated CO2 emissions under the Clean Power Plan, and that the ProSim model is not capable of modeling the Clean Power Plan regulations. I responded that SC&G had been working with a task force set up by the South Carolina Department of Health and Environmental Control for about a year, and that SC&G had developed a special model, a constrained optimization model in Excel, to analyze the state's options under the Clean Power Plan. The model showed that with the units in service, the state could comply with the Clean Power Plan with zero net cost. In short, SC&G has modeled the impact of the Clean Power Plan correctly. Finally, in my testimony, I pointed out that the economic study showing the reasonableness of continuing construction in 2015, 2012, 2015, and 2016, as well as the criticisms of them made by Dr. Cooper and Mr. Richardson, are irrelevant to this proceeding. In Order Number 2012-884, the Commission stated that the BLRA does not require that prudency be relitigated once the initial prudency finding has been made. In the court case, South Carolina Energy Users, the South Carolina Supreme Court concurred with the Commission, with the Commission's ruling, and affirmed the ruling in its entirety. This concludes my summary.
Thank you, Dr. Lynch. Mr. Rafferty, would you please state your name for the record?
Sure. John Howard Raftery.
And by whom are you employed, Mr. Raftery, and in what position?
SCE&G, I'm the General Manager of Renewable Products, Services, and Energy Demand Management.
All right, sir. Let me ask you if you prepared or caused to be prepared under your direction 17 pages of direct testimony that was filed in docket number 2017-370E.
It was rebuttal testimony.
Rebuttal testimony.
Yes.
And do you have any changes or additions to that testimony?
No, I do not.
If I were to ask you the questions contained there today, would your answers be the same?
Yes, they would.
Mr. Chairman, I ask that that testimony be entered into the record as if given orally from the stand.
Mr. Raftery's rebuttal testimony will be read into the record as though given orally from the stand.
Mr. Raftery, I turn your attention to dockets 2017-305E and 2017-207E. Did you cause or prepare to be caused under your directions 2 pages of surrebuttal testimony, which was pre-filed in those dockets?
Yes, I did.
And do you have any changes or additions to that
No, I did not.
testimony? If I were to ask you the questions contained there today, would your answers be the same?
Yes, they would.
Mr. Chairman, I would ask that the surrebuttal testimony be entered into the record as if given orally from the stand.
Mr. Raftery's surrebuttal testimony will be entered into the record as though given orally from the stand.
And Mr. Raftery, I believe there was one exhibit to your surrebuttal testimony labeled JHR1. Is that correct?
Yes, I believe so.
And are there any changes or additions to that?
No.
Chairman, I would move Mr. Raftery's exhibit JHR1 into the record at this time.
Mr. Raftery's exhibit JHR1 will be entered as exhibit number 104.
Raftery, have you prepared a summary of your testimony in these proceedings?
Yes, I have.
Would you please give that to the Commission and those present here today?
Yes. Good afternoon, Chairman Randall and members of the Commission. My name is John Howard Raftery, and I am the General Manager of Renewable Products and Services and Energy Demand Management at SC&G. I'm here today to offer rebuttal testimony in response to the testimony of Ronald Binns of the South Carolina Coastal Conservation League, CCL, and the Southern Alliance for Clean Energy, SACE, Steve Chris of Walmart Stores East LP, and Sam's East Inc., collectively Walmart, and Richard Bodino of the ORS. regarding their discussion of renewable resources, energy efficiency, customer service quality, and electric reliability. SC&G has a very robust program for encouraging renewable resources on its system. In fact, SC&G ranks 6th in the nation with 265 megawatts of solar generation added to its system in 2017 among 423 utilities. SC&G has over 1 gigawatt of solar generation under contract, either online or coming online over the next 2 years. This amount of solar is larger on a percentage basis of system peak than our neighboring utilities. More generally, the General Assembly established goals for both utility scale and customer scale renewable resources in Act 236, and SC&G's program is entirely consistent with those goals. SC&G's specific renewable energy plans were set forth in a settlement approved by this Commission and signed by Walmart, CCL, SACE, and others in this proceeding. Since 2015, SC&G has exceeded the goals established by the legislature and by the Commission. SC&G was the first investor-owned utility in South Carolina to meet its goal for interconnected, customer-scale distributed energy resources, and was also the first to meet its utility-scale goal with 9 solar farms online. Today, SC&G has one of the nation's largest utility-sponsored community solar programs with 16 megawatts of capacity across 3 farms, completely sold out, including a special program designed specifically for low to moderate income customers. Additionally, the signatories to the settlement agreement are invited no less than twice annually to actively participate in a distributed energy resource collaborative led by SC&G, where program updates are shared and participants are encouraged to provide feedback on performance and suggested improvements. SC&G also convenes, no less than twice a year, an energy efficiency advisory group. Similar to the Distributed Energy Resource Collaborative, this energy efficiency advisory group discusses the demand-side management programs of the company and offers feedback on suggested improvements to the portfolio's performance, whether by adjustments, additions, or deletions to the measures or specific programs themselves. CCL is an active member in the Energy Advisory Group, as is the ORS and the State Energy, South Carolina Energy Office. At this time, SC&G is undertaking an exhaustive energy efficiency potential study conducted by a third party to ascertain what changes and improvements are warranted in its current energy efficiency programs. The results of that study will be presented to the advisory group and this commission at the appropriate time next year. Furthermore, the South Carolina Energy Office is conducting a collaborative stakeholder review of current renewable energy programs under Act 236, which is intended to create a new version of Act 236 based on the knowledge and experience gained since that act was passed. Some 47 stakeholders are taking part in that proceeding, meeting twice a month with an objective of proposing legislation or other appropriate regulatory action related to the next stage in the state's development of renewable resource programs. This working group is charged to advance state energy policy and is an appropriate place to consider additional renewable energy and energy efficiency programs in a broad and comprehensive stakeholder process. Walmart, SACE, and CCL are all members of this working group, as are many of the interveners in this case. Regarding the proposals made in the current dockets by other parties, the Distributed Energy Resource Collaborative and the Energy Efficiency Advisory Group provide the procedure for addressing those requests. Furthermore, the company reports annually on distributed energy resource program performance during its fuel proceeding, as well as provide an annual demand-side management filing to this commission. If it is determined that additional review and discussion of the renewable resources and energy efficiency is appropriate within the regulatory process at this time, then the appropriate place to discuss such proposals is within those proceedings, as well as the company's integrated resource planning docket. Equally as important, I do not believe it is appropriate to use the current docket to short-circuit the state energy plan process taking place with the South Carolina Energy Office This stakeholder process should be allowed to reach its conclusion and present its recommendations to the General Assembly. Regarding customer service quality, as the former manager of SC&G's call centers and business offices, I can attest firsthand to SC&G being driven by excellence in customer service. In J.D. Power's Digital Experience Study of March 2018, SC&G ranked 9th out of the 67 of the largest utilities in the United States. In eSource's 2016 study of voice response system, SC&G ranked 4th out of 90 North American utilities. SC&G's overall service satisfaction, as rated by its customers in an after-call survey, was 95%, scoring the highest marks of an 8 or a 9, and the agent courtesy was 96%. Finally, in Market Strategies 2018 third quarter residential scoring, SC&G scored an A- in service satisfaction and an A in customer and field service. Finally, speaking to Mr. Baudino's recommendation on System Average Interruption Duration Index, SAIDI, and System Average Interruption Frequency Index, SAFI, SC&G has long utilized those measures for process improvements reported quarterly to the ORS. Through close coordination related to technology enhancements, vegetation management, and the evaluation of reliability improvements down to the individual circuits, SC&G customers have experienced vast improvements in reliability. SC&G's SAIDI and SAFI scores are at historically low levels and are among the lowest among comparable utilities in our region. SC&G will continue to offer excellent customer service and reliability after the combination with Dominion Energy. There is no reason to impose additional inefficient regulatory reporting requirements on SC&G in this proceeding. This concludes the summary of my rebuttal testimony.
Thank you, Mr. Chairman. Dr. Lynch and Mr. Raftery are available for cross-examination and questions from the commissioners.
Thank you. Okay, cross. Mr. Gile.
Good afternoon, Mr. Lynch. Dr. Lynch, excuse me.
Good afternoon, Mr. Gile.
See you. We've met before. I'm Bob Gile, represent Friends of the Earth and Sierra Club, as I know you know. You close your summary, Dr. Lynch, by offering some what appear to be legal opinions about the Commission's prior orders in these proceedings and the ruling of the South Carolina Supreme Court. Now, you don't mean to offer a legal opinion, do you?
I would guess no. I'm not a lawyer, so no.
Was that portion of your summary drafted by you or by one of your counsel? I'm looking at page 5, the last two lines, lines 21 and 22, extending through the conclusion of your summary, where you criticize Dr. Cooper and Mr. Richardson for the relevance of their critiques of your 2012, 2015, and 2016 prudence studies. You recall that testimony? You remember saying that?
Oh, in my summary, yes, yeah, no, that was my testimony. It's my understanding about the Base Law Review Act going back to 2012. It was explained to me by our lawyers that, after the commission rulings in particular, they confirmed that the studies, the prudency, it was not going to be shouldn't be relitigated.
Those were in cases that sought to revise the project's capital cost schedule and construction completion schedule, correct? Those three proceedings, 2012.
Yes, that's probably correct, yes.
And this is an abandonment proceeding that is under the abandonment provisions of the Base Law Review Act. You understand that, don't you?
That this is abandonment, yes, yeah.
And have you read the abandonment section?
I have not, no.
All right. Well, I've asked you to accept that the abandonment provision not only requires the company to demonstrate that it is prudent to abandon the project, and you're so testifying in this case, aren't you?
Yes.
Right? And that the costs incurred by the company were prudently incurred and therefore are entitled to cost recovery under that provision of the Act. You understand that?
That's my understanding, yes.
All right. And so we will be looking at the decision to abandon the project in 2017 or perhaps at one of those earlier times. And we will be looking at the dollars that were expended that your company now seeks rate recovery from your customer. We will be looking at those things, won't we?
I understand that we are looking at them, yes.
Now, let's just go back to the days of yesteryear, if we can. Dr. Lynch, knowing what we know today, would you have recommended the summer expansion units 2 and 3 new nuclear development project in 2008?
Well, I was thinking in 2008, if we knew Toshiba was going to abandon the project, pull the plug on, change their mind about being in the nuclear construction business, I suppose we wouldn't go down the path. Or we might have chosen a different nuclear project instead of Westinghouse, the technology.
All right, fair enough. What about if gas prices had behaved differently than you expected them to when you analyzed this project, or your company did, in the 2008 timeframe?
Yeah, so if the fracking revolution, or if that started sooner and gas prices were a lot lower, depending on what was going on with CO2, you might delay the move to nuclear. Because the Duke Power, in their IRPs, they had nuclear power, nuclear plants, the AP1000s, in their expansion plan until, I think it was maybe the 2018 IRP is when they didn't show nuclear.
Right, and they canceled that project, didn't they?
I think so. I don't know. It's not in their IRP.
And would you accept, subject to check, that unlike SCE&G, Duke abandoned their project having spent approximately $550 million, not the many billions of dollars that your company spent? Accept that, subject to check?
Yeah, subject to check. But it was in their 2017 IRP. I did look at that.
The gas prices turned out differently. The demand for power, the load growth, the need for the capacity represented by 2,200 plus megawatts of summer units 2 and 3 didn't exactly pan out the way you expected it, did it?
The load growth wasn't there, but the need for the capacity was. I mean, we ended up having to retire 430 megawatts of coal plants. I think it was with the MATS regulations, mercury, air toxic.
But load growth was flat over that period of time. Right?
Load growth was flat, yes.
Load growth was flat not just in the SCE&G system, but virtually nationwide in the utility sector since 2008.
Yes, I think the 2008 Great Recession affected everybody and had lasting effects, yes.
Well, it evidently had lasting effects in the utility sector, but the economy's booming. We've largely recovered from the 2008 recession, have we not? By almost all other economic measures.
You mean the last few quarters?
Yes.
Yeah.
So gas prices, demand, growth. Cost of carbon, you address that in your testimony, and indeed, those of us who are very concerned about the climate crisis have argued for pricing carbon, for internalizing the cost of carbon emissions. But that has not come to pass, has it? And it certainly is not likely to come to pass in the current federal administration, is it?
No, but you still have the EPA's endangerment finding that CO2 emissions harm or endanger the well-being of human life. So that's something that's hanging over that issue.
Yes, but in the 10 years since you embarked on this project, we have not priced carbon, and therefore the price of carbon has not impacted the relative merits of this project. We don't have a price on carbon.
That's correct. In South Carolina, there's no cost to emission CO2.
And then, of course, last but not least, there's the cost of the project, as we now know it to have been and project it to be if we were to have completed the project. That didn't quite turn out the way we expected, did it?
No.
Are you aware that authorities project on the order of a $30 billion price to complete your sister project at Vogtle, 2 units at Vogtle? $30 billion.
I wasn't aware of that. No.
If this project were to cost $30 billion, and we knew that in 2008, it would not have been anywhere close to the economically prudent choice.
I believe that.
Now, you're not a nuclear engineer or a construction manager, Dr. Lynch. I greatly respect your credentials. We've had an opportunity to talk many times, but your field of expertise does not include those subjects, does it?
That's correct.
And I take it that for that reason you rely upon the input of others for estimates of cost to complete this project.
That's correct.
Now, I want to take you back, not quite to the beginning, 2008, but to the time frame of 2011 and on. Now, Santee Cooper, the South Carolina Public Service Authority, is the junior partner, co-owner of the project, correct?
Yes, but 45%, that's a significant piece of the investment.
Exactly.
So it's junior, but still 45%.
Exactly, 45%. But you are aware, are you not, as you sit here today, that Santee Cooper has sought over a period of years to divest itself of a significant fraction of that 45% interest in the new nuclear development project?
Well, significant fraction, I don't know, but I know they were trying to divest some of the capacity. Partly because I remember in 2009, September 2009, they signed an agreement with the Central Electric Co-op in which their load dropped 1,000 megawatts. I think it was 5 co-ops they were serving were now going to get their load somewhere else. So in 2009, the load was down 1,000 megawatts, which sort of negated the 1,000 megawatts of nuclear capacity that they were building. So I could see that they would want to do something about the capacity.
And so you understood that they decided early on in the project that they had a reduced need for the capacity represented by their 45% share.
That's correct, yes.
And when did that information come to your attention, Dr. Lynch?
It would have been a couple of years after 2009, probably.
Right.
I don't remember.
Were you aware of any of the efforts by Santee Cooper in light of that change of analysis of their need for capacity to market their interest to another buyer, another electric utility?
Yes, I knew they were trying to do that.
And were you aware of their lack of success in doing so?
Yes.
And ultimately, the only buyer was your company, SC DN, agreed to acquire back only another 5% of that 45%, and then only upon completion of construction, correct?
That's correct, yes.
Now, did you become aware at any point in time of the work done for Santee Cooper by Dr. Howard Axelrod assessing the economics of the project and the marketability of Santee Cooper's share to others?
Not until these proceedings and some testimony. I didn't know about it at the time, no.
Right. So you only learned about it after the project was abandoned and in the course of preparing for your testimony in the case today. Is that right?
Even beyond that. It wasn't until people started testifying that I came across it.
Actually, live testimony in the case here before the commission.
Oh, it's probably file test. I must have I've read it someplace.
All right.
But
well, did you have
recently.
an opportunity to read Dr. Axelrod's testimony? It's attached, a portion of Hearing Exhibit 81. It was an exhibit to Mr. Rubin's testimony on behalf of AARP.
I looked through it briefly, but I can't say I studied it and remember a lot about it.
Well, you're aware, in short, that he opined in the 2013 timeframe, and again, precisely March 11, 2013, in a subsequent memo. He opined that, in his opinion, having done the analysis, that the summer project was not economic in his time, considering the material variables that bore on its economic.
I had the impression that his conclusion was that if another utility was looking for capacity, they would not build a nuclear plant today.
They wouldn't build a nuclear. They wouldn't buy a piece of The summer project.
Would not buy a piece of this, well, unless the price was right, but at the cost of the plant, they probably would not. And just like I suggested, Duke Power, with a carbon constrained future, Duke Power thought nuclear was eventually in their future, but you would delay it. I mean, that would make sense to me, that you probably build gas with lower gas prices for the number of years coming and no CO2 costs yet, that you would wait to invest in nuclear.
All right. And then the 2013 timeframe, again, talking about Dr. Axelrod's study for Santee Cooper, that he opined that the better choice, the one that was more versatile, more nimble, could meet more reduced load growth, would be a combined cycle gas facility on the order of 300 megawatts or higher.
Yeah, the details of 300, I don't remember that, but the idea was if you're adding capacity, you wouldn't do nuclear under those circumstances at that time.
And that Dr. Axelrod, again, in the early 2013s, concluded that the output cost from a gas facility, combined cycle gas of about 300 megawatts, was on the order of $500 a megawatt hour. And he calculated the cost of the summer nuclear project as twice that, $100 a megawatt hour. Did you note that in Dr. Axelrod's work?
I did not, no.
Do you disagree with that assessment of Dr. Axelrod's, again, analyzing in the 2013 timeframe?
And I guess you meant $50 a megawatt hour for combined cycle, $100 for nuclear?
Yes.
Yeah, I don't contest that.
Moment, please. Dr. Lynch, have you had an opportunity to read the Bechtel study or any of the reports done by Bechtel Corporation to SCE&G management with regard to the status of the project?
Read is too strong a word. I looked at the report, though.
And did you, at what time frame, when did that report come to your attention?
A few weeks ago, a month ago, something like that.
Right. Since
recently, yes.
Since the project's abandonment?
Oh, yeah.
And in preparation for your testimony in the hearings today, you looked at the Bechtel report?
Yes, I would say that, yeah.
Right. Were you a part of the estimate at completion team that's been referred to, the EAC team, internal to SCE&G, that assessed the consortium's data and framed an independent assessment of the likely time and cost to complete the units?
I am not part of the EAC team, no.
Did you participate in any fashion with Ms. Carlette Walker and Mr. Kenneth Brown in that assessment?
No.
If you are the one who is opining, Dr. Lynch, on the prudency of going forward with this project in the past and the prudency of abandoning the project today, why is it that SCE&G management didn't bring to your attention the results of the Bechtel report, their assessment of the project's completion status?
Well, my understanding of, I don't know who had access to the Bechtel report at that time, but my understanding of the Bechtel report was that it was outdated before it came out because we had the fixed price option that predated the output of those results. So the EAC team, as I understand it, dealt with the consortium who was working out a detailed construction schedule, looking for mitigation ways, techniques to even bring the unit in sooner than their schedule had, the schedule that they had come up with for completion. So I'm assuming the EAC team was giving me all the valid, reasonable, good data, best data that they had. And I don't know that the Bechtel report would change any of that. That was relevant, really.
Are you aware that the Bechtel team advised senior management that their likely completion dates included missing the production tax credit deadline for both units 2 and 3?
I don't believe missing the production tax credits on paper is enough to stop continued construction with the units. I just don't believe it was really they were in that much jeopardy, to be honest with you.
But your testimony is that no one with senior SC&G management brought those conclusions to your attention when you performed your prudence analysis and presented that to this commission.
Yeah. Well, it wouldn't come to my attention anyway. It would go through the EAC committee, and then whatever's relevant for the cost and timing of the project would come to me through the EAC or the new nuclear development team. So it wouldn't come to me anyway, if that's your question.
But you did testify before this commission in the 2015 and 2016 cases and did present prudence testimony recommending to this commission that they support continued construction of the projects and that they provide the significant increases in the estimated costs to complete the project. You testified in both those cases, didn't you?
Yeah, I testified that the economic analyses that we had done, based on the information we had available at the time, that the economics suggested that continued construction was in the best interest of our customers. Yes, it did.
Excuse me, I'm sorry. Did you complete your answer?
No, that's it, yes.
But that information that you presented to the commission did not include the material information contained in the Bechtel team's assessment of the likely dates and costs to complete the project. That's your testimony? You didn't know that at the time you testified before this commission in 2015?
In 2015, I didn't know about the Bechtel report. Is that your question? Yeah, I did not know about the Bechtel report in 2015.
And in 2016?
And in 2016, did not know about it.
Because management didn't tell you?
No one told me, yes.
That's all I have. Thank you.
Thank you. Other parties, ORS, or go ahead.
Good afternoon, Mr. Chairman, Commissioners. My name is Elizabeth Jones, and I'm appearing on behalf of the Coastal Conservation League and the Southern Alliance for Clean Energy. Mr. Raftery, I'm going to direct my first series of questions to you, and then I will turn to you, Dr. Lynch. First, I'd like to ask you about SC&G's projections about the amount of solar that it's going to add to its system. If SC&G's projections are correct, you'll soon have 1,050 megawatts of interconnected solar. Is that correct?
Within 2 years, yes.
On page 6 of your testimony, and I could get the Elmo. On page 6 of your testimony, you state, quote, without additional energy storage resources or capital improvements enabling existing plants to operate at lower minimum generation levels, the company will have significant difficulty accommodating the approximately 1,050 megawatts of solar that is anticipated to be installed on its system, end quote. Did the company analyze how storage might be used to accommodate oncoming solar in its last IRP?
You would have to ask Dr. Lynch that. I don't know the answer to that. I didn't do the IRP.
Okay. Generally, has the company analyzed how storage could be used to accommodate oncoming solar?
The company is interested in that and focused on that, and I expressed that interest in this year's fuel proceeding for the remaining 1%. Back to 236, expressed the need and the interest in exploring solar and storage to see what capabilities it could provide to the system. But as it relates to the IRP, I'm not.
Right, and so you haven't specifically analyzed it yet.
We are underway right now.
Okay. And I guess the answer for this next one may be similar, but did the company evaluate improvements at existing plants to accommodate the oncoming solar in its IRP or otherwise?
Don't know about the IRP, but it is another conversation that's active in the company right now, trying to understand, not only what percentage of the system peak in solar generation we will have on the system, but how are we going to operate the system when you have daytime minimum loads. As in my testimony, you'll see an example where it's 2,600 megawatts in the morning. When all of that solar comes online, it drops below 1,600 megawatts. And then to serve the evening peak, once again, it jumps back up to 2,600 megawatts. The challenge will be in meeting those two ramping cycles and having a traditional set of the fleet online to serve the evening peak when the sun is not shining.
But you haven't evaluated yet those potential improvements specifically.
We're in the middle of it right now.
Let's look at a graph on page 9 of your testimony. This chart shows that the winter system peak demand occurs in the morning before the sun comes up. That's right?
Yep.
Okay. And that's when people wake up, they start their day, they turn on their heat. Is that correct? That's what's driving the demand there.
I think it's people waking up, doing their things in their homes. They're also arriving at their businesses. So you get it both from a residential and a business perspective.
Okay. And are you familiar with this year's fuel cost docket directive?
I am, yes.
Okay. On page 15 of the directive, the Commission says the following. While the Commission accepts that there is significant winter need at this time, it is imperative that the company take all appropriate measures to aggressively pursue economic demand-side management and energy efficiency programs targeted at reducing winter peak. End quote. If the company followed the Commission's instruction to aggressively pursue DSM and efficiency, specifically targeted at reducing winter peak, would that mean that the the company could reduce the amount of energy that people demand in the morning?
In theory, yes.
And that would then lower the peak on your graph on page 9?
It would. It's actually Dr. Lynch's graph, but it's in my testimony. Yes. I would add that directive is also part of our exhaustive energy efficiency potential study. So that is where we are examining if there are any economic ways to mitigate the winter peak through demand response programs.
And I'd like to ask you now about efficiency in your programs. Would you agree that efficiency programs can help participating customers reduce their electricity bills?
Yes.
Energy efficiency can reduce the need to generate electricity from fossil plants?
I would defer that to Dr. Lynch to talk maybe about the aggregated impact of energy efficiency and demand response on the integrated resource plan. Yes, I follow your line of questioning.
Ms. Jones, get closer to your mic so we can hear you good. Thank you.
And if efficiency did reduce the need to generate electricity, that would mean that you would burn less fuel and it would reduce the fuel costs that would pass on to customers. Is that right?
Could you say it one more time, please?
Sure. If efficiency did reduce the need to generate electricity from fossil fuels, then that would mean that the company would need to burn less fuel, and that would in turn reduce the fuel costs passed on to customers.
I think that's a logical way to think about it, yes.
Okay. Great. Turning to SCNG's current programs, the current suite of programs was approved in 2013, is that correct?
I believe it was for a 6-year period.
It's so 5 years ago, and it's up for renewal next year.
And another reason why we're doing the exhaustive potential study now, so that we can present it to the commission with the extension of potentially the current programs and maybe some additions.
And in 2013, the company's application was supported by a report from a consulting firm, ICF. Do you recall that?
I wasn't part of the department at that time. They have helped us in the past, and they are helping us now. So, subject to check, I'll accept that, yes.
Okay. And would you agree that they projected energy savings associated with the programs at that time?
It would be my expectation, yes.
Okay. I have a table from that report here. Right, and this shows that the projection at that time in 2013, sorry.
You could have seen everybody up here was like,
Just keep you on your toes. The projection at that time was 136,000 megawatt hours saved in year 6, which would be 2016. Is that what you?
Yeah, I'm not familiar with this chart,
Okay.
but I can see where you put the yellow sticky, and I see 100,000.
All right, I appreciate that.
Yeah, megawatt hours, yep.
Okay. And in the evaluation, measurement, and verification report for 2016, SCE&G reported actually achieving just 53,600 megawatt hours. Is that correct?
I don't have that information in front of me.
Subject to check, would you agree? I have the report here if you'd like to see it.
As the people say, subject to check. Yes, subject to check.
Okay, and would you agree that with those numbers, the actual annual performance of the programs in 2016 was less than 40% of what was initially projected?
Sounds like one number smaller than the other, yes.
Okay, subject to check.
No, I'll go on the record with that.
And is it correct that the actual annual savings of the company's programs fell by about half between 2002 and 2016?
2002 and 2000.
Excuse me, 2012 to 2016.
Yeah, I'm sorry. You are running through a set of numbers that I'm not familiar with. So
Subject to
you'll
check.
need to take your time with me and bring me up to
Sure,
speed.
sure.
Yeah.
All right, well, subject to check, would you agree that the savings from the company's efficiency programs fell by about half between 2012 and 2016?
So, 2012, my memory serves me, was one of the higher years, or the highest years, where we had energy efficiency savings. A number of things have changed since that time, including the light bulb standards from the federal government, from the EPA. That was a major carpet pulled out from underneath us. It probably served almost half of our savings, the ability to subsidize compact fluorescent light bulbs in big box retailers. So that is a large part of the reason why that you saw that decrease.
Mm-hmm. And the actual annual savings declined every year from 2012 to 2016. Do you agree with that?
Subject to check out. Yeah, I'm fine with that.
Okay. Right now, SC&G's current DSM programs reduce retail sales by approximately 0.3%. Does that sound right to you?
No, it's closer to 0.37.
0.37. Okay, thank you. By comparison, the programs of Duke Energy Carolinas reduced retail sales by about 1% in 2017.
I don't know specifically Duke's numbers. I know it's in that ACEEE report that's often been referenced. I do know that SC&G is in the middle of the pack with the Southeast. The amount of energy savings that we have compared to the 10 utilities in the Southeast put us at number 5. Out of the utilities in that report that spend up to $20 million per year, we're third. So I don't know how we compare one-on-one with Duke, but there are some other comparable measurements in the rankings.
Right, changing topics let's talk about the RFP process that you note in your testimony. The guidelines the Commission established for that RFP process specify that the RFP should be utilized for generation only. Is that correct?
You'll need to repeat that one more time for me, please.
Sure. The Commission established guidelines related to the RFP that you identified in your testimony. Is that correct?
In Order 2007-626, yes.
Right. And the guidelines in that commission, in that commission order specify that the RFP will be used only for generation.
I'm pretty sure it says non-base load generation.
Right. Okay. Thank you. So that means that the current RFP is solely supply side focused.
Subject to check. Yes, I really don't know that order in great detail, but.
So if it's supply side focused, that means that efficiency programs would not be considered in such an RFP process.
Not in an RFP process, but then again, I go back to the energy efficiency potential study that we're in the middle of. I mean, it's an exhaustive potential study to examine not only demand-side management activities, but the demand response things that you pointed out as part of that fuel proceeding directive. So that's very broad. I mean, it is no stone unturned.
And you already mentioned that you thought the RFP was limited to peaking generation. So that means that the RFP is not required when the company seeks to procure baseload generation.
Yeah, I'm not an expert in this area, but my understanding is there would be the need for a certificate for public convenience and necessity that would bring about a number of different justifications and proceedings in order to say that new that baseload generation was prudent, and then it's followed up ultimately in a rate case. So there's a couple bites at the apple to debate that issue.
Right. In that RFP process to bring about competitive bidding, it wouldn't then be required to fill any capacity gap left by the VC summer units that have been abandoned?
I think Dr. Lynch is the best to talk about the resource plan and the inclusion or the removal of the nuclear power plants from that plan.
Okay. And as far as you know, the guidelines don't require any independent evaluator?
I don't believe they do.
Thank you, Mr. Raftery. Turning to you, Dr. Lynch. Dr. Lynch, have you read Mr. Raftery's testimony?
Yes, I have.
In his discussion of renewable resources and in response to the suggestion that there should be an RFP process where renewables and efficiency compete with other generation, Mr. Raftery says, and I'll put it up here so you can look at it. If it is determined that additional review and discussion of renewable resources is appropriate within the regulatory process, the appropriate place to discuss such proposals is within the company's integrated resource planning dockets. And he also mentions the stakeholder groups, but I'd like to focus on the integrated resource planning dockets. Would you agree that the company files an IRP each year that interveners can comment on the IRP?
Yes, initial discovery too.
Right. And the company does not have any obligation to respond to the comments put in by interveners?
I don't believe I don't believe that's correct.
And there's no contested hearing?
I think that's always an option. I think it's up to the commission if they wanted it, but I don't believe we have one yet.
Right. And the practice of the commission is to not issue an order in the IRP proceeding. Is that correct?
I think that's correct, yes.
Right. And the IRP includes a 15-year supply plan where the company predicts when it expects it will need to bring on new resources. Is that correct?
Well, it's pretty much an information filing, so you just get a snapshot of what the company sees at that point in time. Not a decision. There's no decisions in there. It's just what we see coming.
Right.
And then maybe a way to meet the load, but yes. Yes.
Okay. And this year's plan shows 504 megawatts of baseload capacity coming online in 2018 and 540 coming online in 2023. Is that your memory?
Yeah, I think the first one's already online. That's that Columbia
Right, this year,
Center.
2018.
Yeah, but that's...
Is it accurate that the company uses two tools to develop its plan? Unit dispatch simulation model, ProSim, and an Excel spreadsheet model?
Yes.
And focusing on that Excel spreadsheet model, I understand that the company makes capacity expansion decisions with that. Is that correct?
Yeah, the ProSim model simulates the dispatch, gives you the production costs. The Excel model calculates the revenue requirements. We do have, we had other models. So like in 2008, we had one of those capital expansion models. The GIAS we got from EPRI. And electric generation energy analysis system. I think that's what it is. That would go in and you would put in all your options and your needs, and it would filter through. It was one of these linear optimization models. And we're currently working on bringing on board a similar one from ABB. So ABB is the vendor who produces ProSim. The next upgrade, there's a portfolio optimizer, I think, replaces ProSim, and then there's a capacity expansion model that also ties into the same database. So in the near future, we will have more better models to study all the options. Not in time for the 2019 IRP, but after that, we should have all this running.
Okay, great. And with the current modeling that you have, is it fair to say that the spreadsheet model, it chooses between specific resources that your team makes available to the model?
ProSim calculates the production costs, and we feed that into the Excel capital cost model. Capital cost model calculates, the revenue requirements associated with all the capital, combines that with the production costs that are fed in it, and so you end up with for a certain expansion plan, you end up with the total revenue requirements. And we would run that for any scenario we wanted to consider. You'd go through that process, and at the end of it, you would have the revenue requirements associated with whatever scenarios or expansion plans you want to consider. So it doesn't really choose, but it calculates what you need to make those kinds of choices.
Right. This is a response to a data request in this year's IRP. You'll see that we asked for the type and quantity of new resources that were made available to the model. And then in the response, you have a combined cycle unit and a combustion turbine. You see that?
Yes.
Okay, so for the model, the company makes certain resources available to the model. And in this case, it's making this combined cycle and the turbine available. Is that correct?
Well, for the 2018 IRP, I mean, all this is changing now. But in the past, when we were looking for coming up with an expansion plan, we were looking at these two ways to meet the load in the future. And so what would happen is you would forecast the peak demand, and based on your reserve margin, it would tell you how much capacity you need. And the cheapest way to meet capacity with dispatchable the resources would be to put a peaker in. So that would give you a base plan with the peaker. And then you would see, well, is it economical to spend more capital and get a more efficient generation of plants like a combined cycle? So we would, and it was sort of a manual process, that's why we want these other models. But we would try, well, let's put a combined cycle here or here or here. You come up with, using the combinations of these two resources, you would figure out which is the most economical expansion plan at that point.
Okay, but so as far as what's actually modeled in the spreadsheet, I understand that you're looking at a combined cycle unit and a combustion turbine, and then you're looking at the various costs associated with those two types of resources.
How they were dispatched among, if they were added to the fleet of resources that we have. And this was for last year.
Right.
And that was,
And so that means that you did not look at other resources like solar and storage or make those available to the model.
Chairman, I would raise an objection. We've gone pretty far afield here from relevancy, and I would object on the grounds of relevancy to this line of questions.
Okay, sustained. Let's move on.
Right. Okay, let's talk about the Columbia Energy Center. I understand that the purchase of the Columbia Energy Center is part of the proposed customer benefits plan. Is that right?
Yeah, I think so, yes.
Okay.
I
And
think it's part of all the plans, isn't it? I don't know. I guess I really don't know.
okay. It is part of the customer benefits plan and a couple of other plans, as you say. And would you confirm that the company analyzed whether to purchase that energy center in 2016?
Yeah, I think we studied it.
And that analysis was to choose whether to purchase the energy center versus continue with power purchase agreements. Is that correct?
I think that was part of the study, yes.
So in that study, you did not look at things like solar and storage as a potential option versus the energy center?
No.
Okay. And you didn't look at efficiency as an option?
Well, we have efficiency in our plan, and my understanding is that the Energy Efficiency Department runs through a cost-benefit study and comes up with all the cost-effective measures that we can use, and we reflect that in our forecast.
Right.
So that's in there.
Right. But you don't allow efficiency to compete necessarily against other potential resources.
No, not now.
Okay. So you didn't look at efficiency or solar in 2016, and you don't look at it in 2018.
Mr. Ziegler.
Well, solar.
Hang on, Dr. Lynch.
I would renew the objection related to relevancy.
Sustained. We're still in we're not in the fuel case, so we need to.
Okay. All right. That'll be it. Thank you, Dr. Lynch.
Thank you.
Thank you, Ms. Jones. Ms. Edwards, are you ready? Mr. Bateman, you ready?
Chairman, I have a few questions for Mr. Raftery that I think I can probably get in under the half past the hour mark, so I'll certainly do my best.
That's a great plan.
Mr. Raftery, how are you?
I'm doing well. How are you?
I'm doing well, thank
Good.
you. Andrew Bateman with ORS. Let's see. Mr. Raftery, in your rebuttal testimony on page 17, and again, I believe in your summary, you stated, and this is a quote, I believe it's also a quote from your summary, but it was certainly something to the effect of, there's no reason to impose additional inefficient regulatory reporting requirements on SC&G in this proceeding. Is that correct?
It is correct, yes.
And have you had a chance to review the testimony presented by other witnesses in this proceeding?
Not all of them, but others, yes.
Specifically, I'm talking about Mr. Collins' testimony. Have you had a chance to review his testimony and exhibits?
No, I have not.
All right, I'm going to either put on the Elmo or pull up on the computer, whatever is easiest. I think we're trying to pull it up right here. So you can see it here, and I've also got paper copies if that would help you. This, and by the way, this is from Lane Collins, Exhibit 8, LK8, pages 7 of 9, and in a second we'll go to page 8 of 9 as well.
I'll take a hard copy.
Okay, sure. Okay, Mr. Raftery, you can see on your hard copy and up on the screen, Mr. Collin laid out a number of conditions, potential for the potential merger. Specifically, one of the conditions, I believe this is the top bullet on the screen there, and I'll read it real quick. For SCNG's electric operations, SCNG shall provide quarterly SAIDI and SAFE reporting, the same as provided by Dominion, shown on Exhibit RAB-12, and that's Mr. Baldino's Exhibit 12, page 1. The quarterly reporting to the Commission should begin no less than 3 months after the close of this transaction. Do you see that bullet there?
I do.
And I believe you discussed this briefly in your summary as well. Am I correct in stating that SCNG already reports this information to ORS on a quarterly basis?
We do. We've worked closely with the ORS over the last 15 years, focused on improving our system average interruption duration index. You might recall, and some commissioners might recall, the effort back in 2008, 9, 2010 to get on a 5-year trim cycle. That is one of the largest items that positively impact system reliability. So as a result of those conversations, we've worked closely with your organization, and we do report them to you quarterly.
We certainly appreciate that close working relationship. Would the company be willing to comply with the condition just mentioned and report this as well to the Commission?
We would. I just would question its usefulness and just the processing, not only within our team, our regulatory group, but as well as the Commission's staff. So Commission so desires it, yes, we would. Absolutely.
Okay. And I think it's the next bullet. Let's go. For SCNG's electric operations, SCNG shall provide quarterly call center performance metrics, reporting the same as provided by Dominion on Exhibit RAB-12, page 2. And again, that's Rick's, Mr. Baldino's Exhibit 2, and I've got a hard copy of that.
I'm familiar with it.
Okay. The quarterly reporting to the Commission shall begin no less than 3 months after the close of the transaction. Mr. Raftery, does SCNG track this information related to its customer service representative's work?
3 of the 4, yes.
Would the company be willing to report that data to the Commission?
Same answer as the other. Absolutely, if the Commission asks for it. There needs to be recognition that we don't track the customer satisfaction with our IVR like that exhibit portrays, but it would question the usefulness and if it's whether that's efficient use of everyone's time.
Okay. And I think the subsequent bullet, for SCNG's electric operations, SCNG shall provide a yearly plan for addressing the 5% worst performing feeders on the company's system. Mr. Raftery, does the company have an annual plan or a plan to address distribution lines that require improvement?
Yes, they do. I can tell you what this will show. It'll show the circuits that are up for trimming as part of that 5-year trim cycle. So it'll say the same thing every year.
Okay. Same thing every year, updated. Is that correct?
We're on a 5-year trim cycle for all of our distribution and transmission lines.
Okay. And same question, would the company be willing to report that data to the Commission?
I find that even more inefficient, but yes, we would if the Commission asked for it.
Okay. And subsequent bullet, for SCNG's electric operations, SCNG shall file a detailed report with the Commission identifying opportunities for improving the service quality to electric customers on SCNG's system within 6 months after the close of the transaction. Does SCNG have a plan to improve service quality for the underperforming areas of the grid?
I'm sorry, you're talking about the last bullet on that page?
Oh, I'm sorry, that's my mistake. It's on pages 7 and 8. It overlaps. It's the last bullet on 7 and the first part of 8 there.
Okay. Yeah, when I've read this previously, I took the service quality to be customer service quality. Are you reading this to be reliability?
That's right.
So every area of our company goes through strategic planning annually and focuses on what needs improvement. I'm not sure. I'm not familiar. I'm not part of this area that would identify, what sorts of opportunities to improve service quality. I would go back to the answer on the other one. It'll be vegetation management. It'll be trimming trees. So I don't know what value at all that sort of report would provide this Commission or anyone else.
But provided that data were available, would the company be willing to share that with the Commission?
I don't think I can say no.
Mr. Raftery, the next bullet, and this is on page 8. For SCNG's gas operations, SCNG shall file quarterly service quality reports with the same service quality metrics shown as provided by Dominion on Exhibit RAB-11. The quarterly reporting to the Commission should begin no less than 6 months after the close of the transaction. Does SCNG track that information related to the customer service representative work?
No, we don't. I mean, that is very specific to the Questar project. It's all focused on gas. It has after-call survey questions very specific to their system, and it doesn't match ours at all. So it doesn't look like anyone took the time to consider our combo electric and gas business and consider what customer service measures should be implemented.
Okay, well, let's move on to the. I think it's the final bullet in that. This is the final question I've got, and I'm under the 4:30 mandate. For SCNG's electric and gas operations, the Commission shall open a docket within 2 years from the filing of the Service Quality Improvement Report to evaluate SCNG's progress on service quality. ORS and other stakeholders may intervene in this docket. SCNG shall be required to submit testimony to demonstrate its progress and experience with service quality for electric and gas operations since the close of the merger. Mr. Raftery, would the company be willing to comply with that condition?
Yeah, and I don't think I can say no. I can say that I find that to be extremely inefficient. I just shared a number of measures that showed our customer service quality is doing very well, even in these troubling times. I mean, our employees work their tails off, both from a customer service and a field service perspective, and they'll continue to do that. The ORS gets inquiries and complaints. They've got the ability to get insight as to whether service quality is failing. The Commission has always had the authority and the right to implement something, if a hearing is necessary, to prescriptively say in 2 years we're going to come back and talk about it. I don't find that to be useful. But to answer your question, yes, we would comply.
Thank you so much, Mr. Raftery. That's all I've got for you.
Thank you, Mr. Bateman. Ms. Edwards. Yeah, let's get a mic so we can hear you.
I have cross-examination get under.
Well then, okay, thank you, and I'll get to you. Yes, sir.
Maybe just a point of order. Tomorrow, we have a date certain witness, George Winnick. So we'd like to use that time to be able to get him up and down to the extent we can. I'm not sure how much cross-examination the other parties have of this panel, but it'd be nice to hear from them as to how much more they've got so we can adjust our schedule accordingly.
And we got commissioners too, so yes, Ms. Edwards.
Always hard to estimate, but if he gives me the answers I want, it'll be fast.
Well, there
we
we
better
go.
buckle down.
Yes, sir, Mr. Witt.
Mr. Chairman, Richard Witt for Solar Business Alliance. Ben Snowden, my co-counsel, will be here tomorrow. We have at least 30 minutes cross for these two witnesses tomorrow morning or tomorrow.
Chairman, if it's helpful, maybe have Mr. Winnick go first, and then if these two witnesses are available, maybe have.
Well, I'm going to allow.
I was just going to say, Mr. Chairman, if we're talking about an hour and a half with ORS and Mr. Witt and Commissioner's questions, then I think that would
We
be
ought to
fine.
be okay.
We should be fine.
Okay. Yeah, I think it'd be best if we can to keep going with this panel and get that done, and we'll judge if it gets long. We'll adjust.
Okay.
Is that all right?
That's
all right with everybody?
Thank you, Mr. Chairman.
Okay. So the one thing we've got, the other little thing we've got is we have a commission meeting tomorrow afternoon at 2. But I'm thinking we've got some business that we just need to take care of. We'll try to work this through. That'll only take hopefully about a half an hour. So we'll make sure that if we do that at 2, we'll start back our hearing at 2:30. but hopefully we will have already started on Mr. Winnick by then. Does that sound agreeable to everybody?
I will always agree with the chairman, so we're good.
That's a great answer. Okay. Commissioners, anything else? Okay. All right. Then everybody had a good evening, and you folks are still under oath, so we'll see you in the morning.